me what's worse than learning all that you led to believe was all horse crap. They distort so question as if you Warshak, horsemen, forcemen, and they've long been having the course map. It ain't that you can't see, cause you can find it home, it's that you don't want to. You cope by putting the blinders on. I've been trying to find some kind of way, but I've kind of known that y'all would rather whine and latch to nonsense cause your mind is gone. I can't save every person, and politicking is bringing the worst out the very earth. And every perk of living on this turf is being chipped at and nerfed, but I can't sit back and lurk. I've got to hit back, I'm certain it's my purpose. And it's a beautiful thing too. Hold up. Yeah, hey, looking at the technological advances. I used to be on dial-up looking for answers. Now what? Underappreciating was candid. And 20 years later, we got computers that hand fit. Used to be playing Sega Genesis with bros. Now I'm gaming with some folks on the other side of the globe. Used to go through a label if you trying to blow. Now people got more options on the table, got a post. Social media got us connected as ever on every medium. Should be more righteous and clever, but what we seeing is communication is error and still the devious. Evil's immediate, tedious that you gotta be remediate, cause idiots get heebie-jeebies in the event that they don't agree with you. Try to ruin your whole life cause you say what they dislike. God forbid y'all disagree without a fight. The type of stuff that will clear up if you lighten up, Jack. Your trifling subject, your life would right if you give up that. You're mad at nothing, not adding up when you're sad enough at a sad second that gets aggravated. And now you pay it forward, let people make your blood boil. Emotions firing like microwave foil or the oil, they annoy you. You add another neck for the wrong reasons. Election years now seeming like full-blown seasons. Man, you let politics ruin, or rather control your whole life, man, you're gonna be a miserable person.
All right, just a moment here. We'll get started. Hey, everyone. Greg Staley here from Diverge Media. Thanks for joining me. I think this one should be, bring a little bit of hope because there has been a decision made by arbitrator John Stout that struck down a vaccination policy. Now, it is a nuanced conversation. We are not going to try to frame it in a way that makes it seem like one side's winning over the other. As many media outlets like to do, they like to have a stand where they can say, hey, look at this, and then have their audience cheer them on because they brought the information for it. The reality is that this is a nuanced legal decision, and we'll get into it. But basically, let's get started. So Hickson Morley put this out. Arbitrator upholds mandatory vaccination policy. Now, let's just pull this up for everyone. Now, the arbitrator, I have the wrong one here. Arbitrator finds mandatory vaccination policy to be unreasonable. This is November 12th, 2021. So this is very recent that this just came out. It was arbitrator John Stout in the Electrical Safety Authority and Power Workers Union case. And we'll go through this a little bit. But basically, Hickson Morley is a massive law firm for this kind of legal work. And they represent many of these cases. And so let's just get into the actual arbitration case itself and kind of explain what's going on. Starting with, pop up here. Again, nuanced. I want to do my best to explain it. It might be a little long-winded, but I think it's important not to pick out the parts that make one side look good, but rather my job as media is to try to remain as unbiased as possible and present both sides of the argument. And so I'm going to present both sides of what the arbitrator presented when he gave his decision, starting with, here we are, number 6. I note that this case is not about the merits of being vaccinated or the effectiveness of COVID-19 vaccines. The science is clear that the COVID vaccines currently being used are safe and effective, reducing the likelihood of becoming seriously ill or dying from this horrible disease. Moreover, vaccinating the population is necessary in order to secure the fragile healthcare system and eventually put this pandemic behind us. So right off the hop, we can see John Stout kind of laying out his beliefs a little bit, that the vaccines are effective in preventing hospitalizations and severe death. And he believes it is a way out of the severity of the pandemic and kind of to end the pandemic. Back into it. Number 7, this matter concerns the interpretation of management rights as found in the collective agreement between the Power Workers Union and the electrical standard. Well, let's get that right. The Electrical Safety Authority. So back to it here. In particular, the focus of the analysis is on management's right as provided for under the collective agreement to unilaterally introduce a rule or policy that all employees must disclose their vaccination status, and any employee who does not disclose their status or who is not vaccinated places their employment in jeopardy. There is nothing, the arbitrator said, in the collective agreement that specifically addresses vaccinations. The Electrical Safety Authority has not previously required any employee to be vaccinated as a condition of employment. There is no legislated requirement that Electrical Safety Authority employees must be vaccinated. I have also not been provided with any prior authority, arbitration award, or court decision that upholds a mandatory employer vaccination rule or a policy applicable to all employees without specific collective agreement language or legislative authority outside of a healthcare or long-term care setting. So this is where it gets important. Now we're getting into the nitty-gritty of kind of the legalese here. What he's saying is there's no collective agreement that he's seen that's from the Employment Safety Authority that specifically addressed vaccinations. Now he continues, we not previously had any employee to be vaccinated as a condition of employment. So this applies out. The reason why this is an important one is this could apply to your workplace if you are in a position where mandatory vaccinations are coming down the pipe now. If it wasn't in the collective agreement before, if it wasn't in an onboarding package that vaccination status or disclosing your vaccination status was a condition of employment, then this may apply to your workplace if they have mandated the vaccines. So, but again, it would be easy for me to stop there and say, great, pats on the back, our side's winning, and then end it there. But it is, again, a more nuanced discussion than that. And I would be doing you a disservice not to fully disclose the arbitrator's decision-making and thinking in the process. Sorry, I'm just going back to my notes. So he added that he had not been provided with any prior authority, arbitration award, or court decision that upholds a mandatory employer vaccination rule or policy applicable to all employees without specific collective agreement language or legislative authority outside of a healthcare or long-term care setting. So unless a legislator mandated it, which it has not happened is my understanding, I could be wrong on that, but it has not happened in Ontario, then this is where we're at. Continuing down here, arbitrators generally apply the KVP test. Now, the KVP test is a test that says that any rule or policy that unilaterally is imposed by an employer and not subsequently agreed to by the union must be consistent with the collective agreement and be reasonable. So this is specifically in representing unions. But basically, if you didn't have it in your collective agreement, it is unilaterally imposed upon the employees, the people working there under the union, it must be consistent with the collective agreement and it must be reasonable. Continuing forward here, he says, the approach to access unilaterally imposed employee rules affecting an employee's privacy. He gives a few examples for the proposition that absent any legislative support or specific language in a collective agreement, employer cannot require all employees to be vaccinated. He said, I appreciate, we're going to read Arbitrator Charney's decision in St. Peter's Health System versus Cube, which is referenced in this arbitration decision as well. He said, suspending employees non-disciplinary for refusing to undergo medical treatment is a violation of their common law, Section 7, charter rights. Pull this up for everyone to follow along. We're right here. For refusing to undergo medical treatment is a violation of their common law, Section 7 charter rights. Virtually all the court cases, including Supreme Court of Canada and Ontario Court of Appeal, find that enforced medical treatment, and I point out that this is not a medical examination, but treatment, is an assault there if there is no consent. Now, this is a separate case. I want to make that clear. And so he references that because it was included in the arbitration process. But he says, I appreciate the analysis of Arbitrator Charney, but I do not agree with this approach. I agree that an individual's employees' rights including the right to privacy, personal autonomy, and bodily integrity, as well as rights under the Charter, are fundamental to a just and democratic society. Such fundamental rights should not be easily abrogated or constrained by employers. However, now this is where I said there is nuance involved in this. I don't want to do people a disservice by giving you a one-sided version of this so that you walk away with a misinterpretation of what's actually happened here. So it is important to really listen in on the language here that the arbitrator, Mr. John Stout, uses. Again, I'm not a legal expert. I want to make that clear as well. This is not legal advice in any way, shape, or form. Please consult a lawyer or a legal professional on this in regards to your specific circumstances as well. Now, however, these individual rights are not absolute. See, this is where I said it is a nuanced discussion. However, these individual rights are not absolute, and there are circumstances where the rights of the collective outweigh the rights of the individual. He says that arbitrator Charney's approach with respect also seems to ignore the fact that some jobs, first responders, healthcare, for example, have an inherent physical component or occur in inherently high-risk work environments. See Halton District School Board and the ETFO BMS grievances. So they're referencing there. He said, I am in the view that a more nuanced contextual approach applying the KVB test and the balancing of interest is the appropriate way to address the issue before me, says C. Sault Ste. Marie and Ontario Nurses Association vaccinator mask policy. Now, continuing down, in cases where the rule or policy involves health and safety, one must consider the obligations that arise under the Occupational Health and Safety Act, including an employer's obligation to take every precaution reasonable in the circumstances for the protection of the worker. It says see section 25.2. We don't have time to go through all the details of this, but the statutory obligation fits neatly within the KVP test. Continuing down, while an individual employee's right to privacy and bodily integrity is fundamental, so too, this is where the nuance comes in. Listen closely. So while an employee's right to privacy and bodily integrity is fundamental, so too is the right of all employees to have a safe and healthy workplace. The interests in this case raise extremely important public policy issues during a very unique and difficult time in our history. The context is very unusual, but the existing law provides guidance for the analysis. In workplace settings where the risks are high and there are vulnerable populations, people who are sick or the elderly or children who cannot be vaccinated, then mandatory vaccination policies may not only be reasonable, but also may be necessary and required to protect those vulnerable populations. Now, in this specific circumstance, the arbitrator struck down the vaccination policy, the mandatory vaccination policy, because, again, he makes the argument that it is nuanced based on the workplace and the workplace setting and the situations that may arise, whether or not it is a reasonable policy. And in this case, he didn't see that it was. Now, he says, however, in other workplace settings where employees can work remotely and there's no specific problem or significant risk related to an outbreak, infections, or significant interference with the employer's operations, then a less reasonable, less intrusive alternative, such as the Electric Safety Authority's voluntary vaccination disclosure and testing policy employed prior to October 5th, 2021 may be adequate to address the risk. It may also be noted that the circumstance at play may not always be static, so it could be evolving. Now we're going to continue down. There's a lot to go through. He said that prior to October 5th, the Electrical Safety Authority had in place this policy, which the company judged to be reasonable and appropriate process to protect employees and stakeholders. Now, some of the concerns that the arbitrator brought forward was that they were going to third-party places where this could have been an issue, where this is they want to have a mandatory vaccination policy, and it could be at high-risk populations, as he discusses here. He said, I acknowledge that testing is fallible and less effective intervention than vaccination. However, it is a reasonable tool to utilize in protecting a workplace. So again, if you're in a workplace setting that isn't around high risk, this is my understanding of it. Again, not a legal expert, but if you're in a workplace setting where you're not surrounded in a high risk setting, and you're not, maybe you're in a warehouse, for example, and you're socially distanced anyways, and then all of a sudden your employer says, look, mandatory vaccination policy, and they don't offer a testing policy. This may be something that could be pointed to now in the process to bring a challenge against that, because this arbitrator saying, I understand it's fallible. I understand that testing is fallible and a less effective intervention than vaccination. This is his viewpoint, but it is a reasonable tool to utilize in protecting the workplace. He says, furthermore, it's been endorsed by the Ontario Chief Medical Officer of Health and the Electrical Safety Authority's expert, Dr. Furness, and he advises that mandatory vaccination along with testing provides maximum protection against transmission. In this case, the ESA has not demonstrated any difficulties in protecting their workplace utilizing a combined vaccination and testing regime. So I believe it's 88% roughly that of the power workers union that is vaccinated. So he's saying in this case, we have vaccination policy. You have many people that are vaccinated. You had a testing policy in place, but now you're saying this isn't reasonable. I don't see why it is suddenly unreasonable to continue the testing policy. At least this is my understanding of it. He says the vast majority were, I recognize that some Electrical Safety Authority employees, inspectors, and eSafe will require access to third-party sites or locations or may need to travel. He said, I am not satisfied, however, that the Electrical Safety Authority has proven a significant problem exists with regard to third-party access and travel, which would interfere with their operations. As pointed out by the Power Workers Union Council, employees provide coverage for various absences on an ongoing basis, and there is no evidence that work has been significantly impeded or lost as a result of some employees, a significant minority, roughly 11.5%, 12%, has been affected by them not being vaccinated. The Power Workers Union has indicated that in the context of mandatory vaccination for travel, they would raise no objection to travel only being assigned to those employees who are fully vaccinated. So the union is making accommodations for the employers' concerns on third-party sites, where they say maybe our third party where we're going to serve would be more comfortable if people were vaccinated. They made an offer, said, listen, we can only send vaccinated employees if this is satisfying to you. This wasn't what the ESA wanted. They instead tried to force a mandatory vaccination policy and got rid of the testing. Arbitrator, in my view, of reading this, was not satisfied with that. And so we continue down here. I'm trying to get through this as fast as I can, so I apologize. I know this is pretty in-depth, but I said at this point, there's only been one instance of entry being denied to an Electrical Safety Authority inspector. In that one case, a vaccinated inspector later attended at the premises and was granted entry for the inspection. The other incidences were addressed by the inspector showing proof of vaccination being granted entry. At this time, third-party vaccination policies have not significantly interfered with the ESA's business. Now, where is a place that would, I believe the federal government or provincial government, they have their mandated policy for vaccination. And this is where they can do that, is my understanding. So if you were part of the Power Workers Union or the ESA and you were going to service one of these places, they could turn you away on that regard. The Power Workers Union says we can send vaccinated employees instead, and it hasn't impeded work. So again, they're not seeing that it's reasonable in this case. Or at least that's what the arbitrator's view is. The other incidences were addressed, and at this time, the third-party vaccination policies have not significantly interfered with the ESA's business. If as this situation unfolds, the Electrical Safety Authority is placed in a situation where a significant issue arises with respect to accessing third-party sites to perform work, then the ESA may have cause to place an employee on administrative leave until they are vaccinated. But it hasn't to this point. So again, nuanced discussion. Would love to say like, hey, look, silver bullet, look at this, and it's great, and let's all pats on the back, and it's going to be fantastic. But again, I'd be doing a disservice to you if I didn't lay it out exactly as the arbitrator has laid out. Now, the ESA has only 1 point. This is, again, back to the arbitration decision. Only 1 point to one actual complaint arising with respect to the conduct of an inspector. Now, this complaint is found on October 1st. The homeowner expressed disappointment with the conduct of an inspector. One of the concerns expressed was the refusal of the inspector to provide a valid negative COVID test or vaccine confirmation prior to entering the home. This one issue could have been addressed under a policy that combines vaccination with a testing alternative, is what the arbitrator says. Continuing down, it would appear that in early September, the Electrical Safety Authority was satisfied with their policy of vaccines and testing, but later had second thoughts. So this is where I said that nuance comes in. Arbitrator is addressing that. He says there does not appear to be in any event issues or concerns brought to the Joint Health Safety Committee for review and recommendations. In my view, it appears that the safety that the ESA rather has jumped to a hasty conclusion without turning their mind to the validity of concerns and analyzing the concerns if the concerns will manifest themselves in serious workplace problems that cannot be addressed by a policy that combines vaccination with a testing alternative. In my opinion, the Electrical Safety Authority has acted prematurely and without considering the individual's rights of employees. As a result, I find that there are certain aspects of their current vaccine policy are unreasonable. The Supreme Court can, as a number of occasions, recognize where work is fundamental to one's identity, providing a means of financial support and a contributory role in society. It gives reference to a court case there as well. In my view, disciplining or discharging an employee for failing to be vaccinated when it is not a requirement of being hired and where there is a reasonable alternative is unjust. Employees do not park their individual rights at the door when they accept employment. While an employer has the right to manage their business in the absence of a specific statutory authority, a specific provision in the collective agreement, an employer cannot terminate an employee for breach of a rule unless it meets the KVP test and found to be a reasonable exercise of management of rights. Now, to bring in this nuanced discussion a little bit more, there was a case where an arbitrator recently advocated for the mandatory vaccination policy. Now, this is, again, when we talk about the nuance that John Stout brought forward, he's saying it's specific to the employer conditions that the employee is going to be in. And in this case, it doesn't make sense to him. He doesn't see this other case at odds or ends with his decision, but rather sees it as complementary. And so we're going to go to that one real quick. And that is arbitrator upholds mandatory vaccination policy. Again, this is Hicks and Morley, a large legal firm representing these types of actions. Now, on November 9th, arbitrator Von Vey upheld the mandatory vaccination policy implemented by a security company. I believe it's Paragon Protection, finding that the company acted reasonably in implementing the policy and that it did not breach the collective agreement. It says that the employed approximately 4,400 security guards represented by the union who perform work at about 450 client sites. Many of the company's clients had either implemented mandatory vaccination policies, which required, among other things, that the company's security guards in their role as client contractors. Again, they're specifically client contractors. You can see there's difference in this. There is nuance to be fully vaccinated or advised that the company that they intended to introduce such mandatory vaccination policies in the near future. The company therefore implemented a policy which required its employees to be fully vaccinated and sent out communication to all employees prior to that date, notifying them as such. They are provided with and must complete a vaccination status declaration form. So these are, it's different in the sense that they were, my understanding, again, independent contractors to the clients themselves, kind of being subcontracted by Paragon. So different, but we're seeing this is maybe the tides turning because, again, if you're in a workplace where this doesn't make sense, you didn't sign an onboarding package that says you parked your rights at the door and you said, hey, listen, it wasn't mandatory for me to get vaccines in my employee package, and it doesn't affect my ability to do my work, and I'm open to reasonable alternatives. This may be something that you can now point to in that case if your employer is mandating vaccines with no testing alternatives or no alternatives in general to prove that you're, I guess, not a risk or not going to put others at risk, rather. So we're going to continue here back to the ruling, and we're just got a few more points here I want to drive home. It says all individual employees' medical information must be kept safe, secure, and protected from disclosure. Such medical information may only be disclosed with an employee's prior consent. It is preferable that disclosure be limited to healthcare professionals. Again, it is preferable that disclosure be limited to healthcare professionals. Although, and then this is the nuance again, one must be aware in a world where you are either fully vaccinated against COVID-19 or you are not, then it may not be possible to fully protect an employee from inadvertent disclosure. In addition, it is fair and reasonable for employees to have the option of granting the employer the right to disclose their vaccination status to third parties for the sole purpose of accessing work sites. So again, this is where that nuance comes in. It may be reasonable, he's saying, for your employer, if you need to access third-party work sites, maybe a federal government institution that has a vaccine mandate, or a place like that has been deemed reasonable for them to have this mandate, it may be reasonable for that employee to disclose your vaccination status in that case. So it is not a silver bullet decision here, but I do think this is a good foot in the door for people to start referencing. Don't believe there's any reference to natural immunity, unfortunately, Tim. Back to the decision. It says, in addition, it is fair and reasonable employees to have the option of granting the employer the right to disclose. We just read this. However, such consent should not be required, and any consent granted must be clear. So consent should not be required, should be optional, and any consent granted must be clear, knowledgeable, and with the ability to be withdrawn. Okay, go down here. On a final note, after the hearing, I was provided with the arbitrator Von Vey. We just read this decision. I said, I need only state that the award arises in a different context involving a different union and a different employer, a security company whose employees perform all their work at third-party sites, and specific language in their applicable collective agreement that requires employees to receive a specific vaccination required on an assigned site. In my view, the Von Vey award is clearly distinguishable. It does not lead me to a different result, and moreover, I do not see his award conflicting with my decision in this matter. Rather, I am of the view that in this circumstance before arbitrator Von Vey, he came to a reasonable decision. In closing, after carefully considering the party submissions and for all the reasons stated above, which will be elaborated upon in due course, I am allowing the grievance and making the following orders. The Electrical Safety Authority is directed to amend their vaccination policy to make it clear that employees shall not be disciplined and discharged for failing to get vaccinated. The ESA is directed to provide a testing option to those who have not been vaccinated. The ESA may revise their vaccination policy to indicate that at some point in the future, if problems occur in their operations or safety concerns become such that they cannot be adequately addressed by a combined vaccination and testing regime, then with reasonable notice, the Electrical Safety Authority may place employees on an administrative leave without pay if they are not fully vaccinated. Again, I don't think this is a silver bullet. It's not a great decision in my mind, but it does give a foot in the door to some argumentation here on mandatory vaccination policies that don't offer testing. In a lot of cases, I'm sure that it is reasonable to have alternatives, and it's not going to impede the safety of the other employees at the work site or of the customers that they serve. Now, it says the ESA's vaccination policy may require employees to confirm their vaccination status as long as their personal medical information provided by employees is adequately protected and only disclosed with their consent. The Electrical Safety Authority may amend their vaccination policy to provide employees with the option of providing a general consent to disclosure of vaccination status in order to assess third-party premises, or an employee may reserve the right to disclosure on a case-by-case basis. The Electrical Safety Authority is to provide a copy of their revised vaccination policy together with this award to the Joint Health Safety Committee and advise them of any and all concerns that they may have about the safety in the workplace and at third-party sites. The Joint Health Safety Committee shall have a reasonable period of time for review, so they may identify any of their own dangers or hazards and make written recommendations to the safety authority. If concerns still exist and the situation has evolved to a point where additional measures may need to be made by the ESA, but the power worker union objects, then the matter may be brought back before me on an urgent basis for resolution. As I stated at the beginning, this award should not be taken as vindication for those who choose, without a legal exemption, not to get vaccinated. Those individuals are, in my view, misguided in acting against their own and society's best interests. These individuals may also be placing their ability to earn a living in jeopardy. These individuals should not construe this award as a victory. I remain seized to address any issue fairly raised, but not addressed in this award, including implementation of my orders and providing more fulsome reasons at a later date. So again, not a silver bullet decision, as I'm sure you will soon see in the near future. Some outlets, some media pundits, some influential characters pointing to, but it is a foot in the door for some argumentation, and that is a little bit to be hopeful about. In a time where we're watching our rights be stomped all over, You can see this arbitrator who clearly is on the side of vaccines, clearly believes this is the way out, still couldn't just come out and say in good conscience that this was a reasonable thing to do in light of the fact that there's nuance to this. If they're doing remote work or there's safe distancing at work, things of this nature, other PPE is being provided, then a testing policy in combination with a vaccine policy can be deemed reasonable and may not be justification to be released. So one of my sons is an electrician here in Saskatchewan. I told him to talk to his boss regarding testing as an option of the vaccines. He had to get both shots or he would be fired. So Tim, I would recommend that if he has a union, to bring up this decision with the union. It could be different in their case. Again, I'm not a legal expert, but it could be different in their case depending on who they serve, what the nature of it is, and are they vulnerable populations, etc. But if it is a similar situation, this could be something that's pointed at to as testing could be deemed reasonable in that case. If both jabbed and unjabbed can carry and transmit, a test policy should include both. I would agree with that, but I'm not sure what the take of an arbitrator or a court decision would be on that. But that's basically it. We're going to wrap that up. I think we're starting to see some of these things crumble. We're starting to see the reasonable arguments starting to come through. Because, again, even someone like arbitrator John Stout, who is clearly in favor of COVID vaccination, is clearly in favor of people getting it and thinks it's the right thing to do, couldn't just outright say, based on what the law is written, that this is going to happen no matter what. He's still saying you need to have a reasonable alternative unless there's, my understanding, at-risk population or maybe a third-party situation. But again, this is a nuanced decision. Don't let people mislead you and say this is a silver bullet. Look at what's happening. Rather, it is a nuanced decision. As you can see, the judge rewarded. A judge said at the end, the arbitrator rather, said these individuals, again, I'll just read this last line for you. He said, as I stated at the beginning, this award should not be taken as vindication for those who choose without a legal exemption not to get vaccinated. But those individuals, in my view, are misguided and acting against their own and society's best interest. These individuals may also be placing their ability to earn a living in jeopardy. These individuals should not construe this award as a victory. Again, nuance to this. But again, in certain circumstances, when you're not dealing with the public, maybe it's remote work or maybe you're socially distanced at work anyways, if they're implementing a mandatory vaccination policy, my understanding of what I've read is that if you're not in a situation where other employees are at risk as a result, or it's the public's not at risk, that maybe a testing policy is a reasonable measure to consider. So thank you for joining Diverge Media. I have lots of stuff coming out this week. Again, I apologize, I'm behind on editing, but we do have, I'm just going to give for the for the people that are here, we're going to give a little sneak peek. I told you I got the Sarnia funds back, and we were told what the $450,000 that the city of Sarnia got for to rebound from COVID was used for. And so I'm just going to tell you all before the video comes out, drum roll, they used $450,000 to rebound from COVID to upgrade a skate park. So that video is coming out and the details of that will be coming out. And I just interviewed Matea Murta. She's a very, very interesting woman. She has a lot of credentials. She's worked for a cabinet minister. She's worked in politics. She now represents family rights, and it's also advocating for family rights and those values at the United Nations. She also runs a non-governmental organization. So I'm working on editing that, hoping to have a video on the skateboard park in Sarnia with the COVID money out Tuesday, Wednesday. I apologize. It's a lot of work for one person to be doing. And then Friday, we'll have another interview out again with Matea Murta. I'm excited to bring you both. Thanks for tuning in. We'll catch you next time. Thank you.